Hi everyone, I'm Suksan Popangam. Now I'm the intern at Saga Asia Consulting. Today I would like to discuss about the issue of termination of employment contract under Myanmar law. Terminating employee is one of the most unpleasant aspects of business operation, but sometimes it's absolutely necessary in order to continue the business of the employer. If terminating an employee is really necessary, then it should be done lawfully to avoid unwanted legal consequences. The decision to terminate an employee's employment always carries with it the risk of possible legal challenge. Like in other jurisdictions, an employee may have a breach of contract or wrongful termination claim against an employer. Still, there are some significant differences between Myanmar employment laws and the employment laws in other jurisdictions. We should therefore make sure that the employment is terminated legally under Myanmar laws to avoid unnecessary problems from such termination. First point that employers should always bear in mind is that all employment contracts in Myanmar must follow the standard employment contract template that's prescribed by the government. Secondly, terminations of employment must comply with the terms and conditions under the standard employment contract templates. The point is that severance pay is required to be paid upon the termination of employment contract by the employer. This is pursuant to the notification number 84/2015. The amount of compensation depends on the time of consecutive employment of employee, with severance payment of 1/2 monthly salary after a minimum employment period of at least 6 months, up to 13 monthly salaries for employees having been employed for more than 25 years. If an employer decides to terminate employment with an employee, the employer must inform employee 30 days in advance within a sound reason. The standard employment contract template. It is possible to terminate the employment in 3 circumstances. 1. Winding up of the business of the employer. 2. Suspension of business due to unforeseeable events. And 3. Death of employee. As you will see, this is a combination of termination with cause and a termination without cause, like in other jurisdictions. Unavoidably, the term "with a sound reason" can cause disagreement between employers and employees. In this regard, a disciplinary dismissal can be regarded as a sound reason for terminating the employment in Myanmar. But employers must ensure that our work rules, including a list of disciplines, is properly annexed to the employee's employment contract. Moreover, disciplinary actions required by law must be strictly followed. In the event that an employer does not comply with his or her disciplinary obligations, the employer must issue 1 oral and then 2 written prior warnings of non-compliance to the employee to provide such employee with the opportunity to rectify his or her conduct. For the second written notice, the employer must ask the employee to sign a pledge undertaking not to violate the disciplinary obligation again. And after that, if there is any further violation within 12 months from the undertaking, the employer is entitled to terminate the employment contract without payment of severance pay. Still, there are some aspects of Myanmar employment laws which are still unclear and in need of precedent setting by the relevant authorities to confirm their practicality. For example, it is still unclear whether a summary dismissal or an immediate termination of the grounds of grave misconduct is permitted under Myanmar law. Since the standard employment contract template is silent on this issue, some lawyers suggest that an immediate summary dismissal is permitted under Myanmar law. Or like the issue of employers' right to pay in lieu of notice of garden leave, Myanmar laws do not provide for payment in lieu of notice or garden leave, but it is often written into internal policy or agreed at the time of termination. This is the issue of employment termination, and thank you for watching.